and good afternoon. I don't feel like a rock star, so. So I'm going to talk about the fascinating area of conservatorships. As you are aware, as aging occurs, any number of problems can arise. And oftentimes, in my world, which is the legal world, we find that people, when problems start to arise, they immediately say, well, you need a conservatorship. And that may or may not be the right answer. So when we talk about conservatorships, we look at it as the very, very, very last resort. This is not the first resort. This is not the first thing that we do. Normally what happens is that life goes on, the golden years are upon us, whatever you want to say, and then there's an unexpected event that occurs. Sometimes it's a gradual decline, but along the way there is something that occurs that makes everyone think that there's no alternative other than to get a conservatorship. Now, what is a conservatorship? It's a public proceeding through the court. And I emphasize the word public because now we are, if you will, airing dirty laundry. What you can't do for yourself anymore. And it can involve either personal care, habits of personal care, for example, bathing, eating, medication management, toileting, all of those things, which you can't do for yourself anymore, what bizarre things are happening at this point, or it can be financial affairs. The court will review all the evidence that's put before it, and unfortunately we have to put this kind of evidence before the court and then make a decision. And sometimes we will go into a conservatorship thinking that we have all the evidence of the world and this should be an easy thing to establish. We have a great need, we can feel the pain of the family, whatever the circumstance is, and then the judge will start asking questions, and maybe the proposed conservatee, the person that we're talking about conserving, will say, hey, wait a minute, this is not what I want, and I think I'm doing fine. Conservatorships are very, very serious judicial proceedings in that we are literally removing civil rights from a person. And so the judges look at this as a very, very serious proceeding. And the code provides that in conservatorship, the conservatee, the person who is not managing well, the person we think is not managing well, the conservatee has the right to a jury trial. So that's how serious this is. It's not something we take lightly. So it's not our first step, go-to way to handle a problem. In my mind, there are some issues outside of removing civil rights. One, that it's a public proceeding. All the dirty laundry's out there, as I said. Two, it's extremely expensive. And it's extremely expensive because there's a large volume of paperwork that has to be assembled in order to fully petition for a conservatorship. So it's not something, like I said, that we go into lightly. When we talk about conservatorship of the person, we are talking about a person or a need that exists because a person is not handling their physical care well. And that can be health care, providing for food, clothing, and shelter. It's kind of the basics that were just talked about with the APS. And then there also is conservatorship of the estate, which has to do with financial management, financial resources, the ability to manage your property and financial affairs. An often forgotten part of the ability to manage your financial affairs is the ability to resist fraud or undue influence. Literally, you can have a person who can go to the bank, do banking, write checks, balance a checkbook, and be suckered in by the next pretty person that walks by, or the nice person at the grocery store, the clerk at the grocery store, or somebody else who's inappropriate in terms of management. Very, very, very important component of conservatorship of the estate. So I have put up on the screen the confidential, what we call the confidential supplement, the confidential supplemental information that we provide to the court. And I did this because I think that this kind of shows you the depth of information we have to provide and what the court looks at in terms of assessing whether or not a conservatorship is necessary. It's labeled as confidential because we do file a petition with the court and we do make certain allegations in the petition. Dad can no longer manage his own medications. Dad cannot keep his house clean. Dad hasn't taken a bath for 6 months. Dad has so much stuff in the house that he's sleeping on the sofa and that's the only place that's available. Dad can't cook for himself. All of those kinds of things we say in a very general way in the petition. But then we get into the confidential portion and we add the details of all of those simple statements that we have made. This is, in my mind, the most important part of your overall petition to the court. You'll see it says do not attach to the petition. It goes into a separate part of the file that is not open to public viewing. And I have to say that I applaud our probate court is very, very, very sensitive to the nature of conservatorships. While all court proceedings are public, and in fact you can go online now and get a lot of information about court cases that are going on, they will not post conservatorships online. And the reason is that while it's public, they say if somebody wants to come down to the courthouse and fill out a slip and look at the file, that's okay, but we're not going to put it out there for the world to see. So I appreciate that. I failed to mention the emotional toll that conservatorship takes on a family, in a family, because you may have people in the family who disagree as to the level of dad's need and what's going on. So you can see on this first page that it says on box 2, this person is unable to provide for his or her personal needs. And then you provide in detail the facts regarding physical health, food, clothing, and shelter. And oftentimes this space is not sufficient to say all that you feel like you need to say. And I'm going to use this magic thing with arrows on it to see if I can go to the next page. Number 3 talks about unable to manage financial resources, and this is where you talk about the ability to manage property and financial affairs, and also the ability to resist fraud or undue influence. Let me look at my notes here. I wanted to make some comments on these. As I said, it's more than just being able to pay your bills. It's knowing the assets of your estate. And sometimes people can be this is an interesting area when we're dealing with people who are losing capacity to manage their own affairs. Because depending on their background, they can present as very well organized. I had a woman one time who was in one of those scams where they sent, if you'll just send in this amount of money, we know you're a winner in this contest. You know those scams, you've heard of those a long time ago. But she had been a secretary, and she had file boxes very neatly organized of all of these notices that had come out on if she just sent in the money. And she treated them like bills. She'd write the check number and that she sent in the money and the date and everything else, not realizing the scam nature of what was going on. And I don't know if you've ever had the opportunity to listen to some of the messages that these people can leave. They call often on the phone. I had a client one time who thought she was going to win big out of some class action lawsuit. And she would come in and I kept saying, Helen, no. Helen, no, they're scamming you, they're scamming you. No, this is serious, this is serious. Of course, they would call at night when she was lonely. They'd talk to her, they'd ask how she was doing, they befriended themselves to her. So she told me that they would leave messages if she wasn't home on her machine. You know, remember when we used to have tape machines? Anyway, so I told her to bring in one of the tapes one time, and she did. And we played it, listening to it together, and I was floored. If you listened to it the first time through, you were convinced that this was legitimate and they were concerned. Absolutely convinced. I was horrified myself. And so then we played it back through, and I said, Helen, please listen to this and tell me what information, what specific information they're giving you. And there was not one bit of specific information. It was all generalities. You know, the judge was not able to hear it. It's going to go over till next week. So now we have to make another appearance, and we're going to need some more money, and we'll call you back. But there were no specifics about the case or what was going on. Anyway, it's pretty frightening what's out there. And these people are good. They're very, very good. The ability to resist fraud or undue influence, you may know. Some examples I can give you quickly. There's a gardener that comes every week, and we're really glad for the gardener because it's a contact for Dad. But now the gardener starts talking about his son who's ill, and they don't have enough money to go to the doctor, and so could you just give me $100 so I can go to the doctor, and then it's $100 next week for something else. And that scenario, I've had a lot of gardener stories. A woman goes in to get her hair done every week and starts talking about not being able to balance her checkbook, or maybe the hairdresser notices she's having trouble writing checks. And so the hairdresser says, hey, I'll just come over to your house once a week and I'll write the checks out for you. And you can just sign them. These are inappropriate people becoming involved in somebody's really most private affairs. Another issue that arises is mobility. We always think of incapacity as mental incapacity, but mobility can be an issue. Blindness can be an issue. I have a client who is out there who can get to the bank but can't see or process the ATM, so will hand her card to anybody who walks by and say, my PIN number is 1234, could you please get me $100? And has no way to verify that it's only $100, and now has given out her PIN number to somebody else. So these things do happen, but at what point do they rise to the level of the need for a conservatorship? And what can we do in the meantime? And I want to point out number 5 here. What can we do in the meantime to try and get around this? We have to explain to the court in detail why the alternatives to conservatorship have not worked. And one of the things I have to work with my paralegals on is they'll say, well, we tried it and it didn't work. No, we need some detail here. So why is voluntary acceptance of assistance not possible? I'll give you a perfect example. One I've been working on this week. I have a man who became ill 2 years ago. Not my client, but Dad became ill 2 years ago, was in the hospital. The doctor said he can't manage his own financial affairs at this point. Oldest son was named under his trust and his power of attorney to take over and do the management. Son has taken over since that time and done the management. Well, Dad's gotten better. He's gotten physically better, maybe not mentally better at this point. And so now he's saying, my son is stealing from me. I want my money back. And when he has shown many signs that he cannot manage his money. He has a drinking problem is one of the problems. But anyway, many signs he cannot manage his money, and is fairly wealthy, has a lot of people, has 20 tenants, most of them pay in cash, takes the cash, has wads of money in his pocket, long story. But anyway, so now he's accusing his son of that. And further, son tries to sit down and go over things with him, and then he doesn't quite remember that son has done this or the explanation of how the money's being spent. And so now dad, who has 2 gun safes so full that he can't put another gun in, so there's one sitting on his nightstand, is threatening to kill his son. I'm going to kill you, and then I'm going to kill myself. You know, so these are when things go awry, and this is when voluntary acceptance of informal or formal assistance doesn't work anymore. Okay, so you have these kinds of things that occur. Powers of attorney. Powers of attorney are a double-edged sword in my mind, because you can name somebody to act as your agent under the power of attorney, sometimes called an attorney in fact. A lot of problems can exist. We have all the laws on the books to make powers of attorney good. And you go to the bank and you have a problem getting your power of attorney accepted. That could be one problem. It amazes me that if you have somebody who's trying to manipulate the system or take advantage of another person, they always can get the powers of attorney to work. It's the honest ones that can't get it to work. I don't know, it's just my observation. Powers of attorney have to be current. They can't be too old. I met with a woman this morning and I said, and I've met with her for years, since the early 90s. Joan, your health is not as good as it used to be. I meet with you every 2 to 3 years. Sometimes we'll meet many times and then I won't see you for several years. Now we need to meet on a regular basis because her health is declining. One of the problems with power of attorney is that it's not keeping up with the current circumstance, the financial circumstance, and who is the right person who has enough time to set aside to act on your behalf. And is this the right person? Big issue. The form asks about limited powers. That's to do one specific thing like banking, or general powers, and those are broader to manage your financial affairs. Powers of attorney, there's a big misconception that if you have a trust, you don't need a power of attorney. Powers of attorney and trust do not touch each other. You use a power of attorney for things that are not in the trust. You use the trust for assets funded into the name of the trust. Okay? So power of attorney is an alternative. You have to keep it up to date. Biggest issue, you have to get the right person in there. Then they ask about the power of attorney for health care. Actually, there are many components to the health care puzzle. You've got the advance directive, which is the component that talks about who will make my health care decisions for me when I cannot communicate those decisions for myself. Has to be the right person, has to be kept up to date. And here's why it has to be kept up to date. Because now the hospitals have to ask when you come in for an outpatient surgery, do you have a health care directive? That's what they're supposed to ask, and that's what they do ask. But oftentimes if somebody says no, or I don't have it with me, they'll slide one across the table. Well, the person they're going to name now is the neighbor who brought them in, and not the son who was named on the prior one when all the thought and legal action went into it. And so now we have revoked the prior one and named the neighbor as the person who is responsible for health care. Big problem. So, you know, just encouraging people to be aware that when there's a change, we need to get the right person in place and always take your health care power. And now there are many ways you can do it. You can actually carry cards where it can be faxed in, or you can carry a flash drive that it can be inserted into a hospital computer. The second component of a healthcare directive is the right to receive protected health information, and this is under the HIPAA law. HIPAA laws came in, and now things are shutting down in terms of privacy and access to that protected health information. I have even seen it to the point of a wife calling the doctor to make an appointment, and the doctor says, "Why isn't your husband calling?" he's asleep. Maybe he has dementia, but they won't make the appointment unless he gets on the phone. It kind of gets in the way a little bit, and so I tell my clients, be sure and tell when you call for your spouse that you have a HIPAA release and you can make this appointment. Also, with regard to health insurance, you need those HIPAA releases so you can find out what's going on with the billing. So very, very important. And then the third component of healthcare is the POLST form, which P-O-L-S-T stands for Physician's Order for Life-Sustaining Treatment. And I can say this, but I'm not sure of it. It seems to me that this form is replacing the DNR form, because it has on it, do you want CPR if you don't have a pulse and you're not breathing? And then it goes into some alternatives. If you do have a pulse or you're breathing, do you want comfort care only? Do you want limited intervention? Do you want full care? And so this is a form that you discuss with your doctor. It requires a doctor's signature on it. It's always on bright pink, thick paper. They're trying to standardize it so it stands out. In the medical file, it is a physician's order. I always ask my clients to get a second one to put up on their refrigerator, and actually it's been kind of nice as I've been in clients' homes and seen them up on their refrigerator. If you're to the point of saying, I don't want extensive measures, I want comfort measures only, have that on your refrigerator so if there is a problem and the paramedics come, they can be presented with that form. So these are some alternative things that we're talking about in terms of alternatives to conservatorship. Many of you know about trusts. Trusts are an entity meant to capture assets, to name somebody who will manage when you cannot manage for yourself. And then what other alternatives have you looked at? Okay, so you get to all of that. Number one, you have to have the right person in place. And more with the fractured families that we see out in our society, using professionals is a very good idea. Somebody who is independent of the family, who can keep the family informed, but you don't have family fighting with family. And that oftentimes happens. And then keeping the documents up to date. Absolutely, absolutely important. And up to date at times in a person's life can be every year, every 6 months. In a normal situation, probably every 3 to 5 years. So even with all of these good things in place, sometimes we need a conservatorship. And you need a conservatorship for situations like I described earlier, where dad has his estate plan in place. We have somebody managing the finances, but he is making very poor decisions regarding his personal care, cannot manage his own medications, etc. I'm trying to think how much of this I can say because it's a current case. But, you know, just kind of doing some bizarre things, and then how much of that overrides what's been done, and we can get into the conservatorship court. The key to all of this is to be able to have an evaluation so that a doctor can sign a capacity declaration. In this particular case, I'm making the doctor my new best friend because the doctor's the one that said to the son, sounds like you need a conservatorship. Son makes an appointment, comes in. We say, gee, this sounds like there's enough information and we probably do need a conservatorship. So we sent the capacity declaration over to the doctor and he refused to fill it out. So I'm on the phone with this doctor who's very concerned. He's not a bad guy, but he's very concerned. But he says, I just don't think there's dementia. And I keep saying, well, we're not really asking about that. You know, do you know he's doing this and this and this and this? So we're talking on a daily basis at this point. Anyway, I have a few minutes, maybe I can answer some questions. Conservatorship, like I said, is not the be-all and end-all. You want to try everything else in the world you can before you get to conservatorship court, but it is a very fail-safe thing to do if you can get conservatorship. It doesn't mean all the problems are going to go away, but you do have in place a way to manage those problems. Are there any questions, Stella?
Nancy, on the confidential report that you mentioned, is that, and you said it's not for public, that the
Right.
person would have, is that just locally or is that statewide?
Statewide. It's a statewide part of the conservatorship packet that we submit to the court. So it is a state form. Yes, ma'am.
And you said a professional would be better to handle the POA in some cases to not have
Right.
family members. Why is that an attorney like yourself or
No.
other professionals?
The question is with regard to the professionals I mentioned. There is a great group of people called professional fiduciaries. We are aware of corporate fiduciaries, which are banks, but professional fiduciaries are acting on a more individual level, and they are people who are licensed through the state of California and have taken classes to know how to manage the affairs of others. Acting as a fiduciary, whether you're a family member or a professional, is a very, very serious responsibility, and the court puts a lot of burden on you. It's almost, in my mind, a strict liability. You have to be so careful about what you do and account for everything you do. Part of the problem we have when family members do it is not that they don't care, that they're not loving, that they're not doing the right thing. They just don't keep good records, something goes south, and now we're before the court because there's some kind of a problem. So professionals fill that role very well, and as I said, it keeps family members from fighting with each other. Oftentimes the person in charge is not well liked, or they don't agree with that person's decisions.
Fiduciary represents the healthcare power of attorney?
Sometimes you can do a fiduciary on the healthcare power of attorney, and let me give you an example of how simple this is. On the healthcare power of attorney, my preference usually is to use a family member. This is somebody who knows the patient well, knows how the patient would feel about healthcare, and can make decisions based on their knowledge of the patient. But I'm dealing with an issue right now. Yesterday this was an issue. Two sisters, mom died, dad had died previously, dad was cremated, so they cremated mom, and now they can't agree on what to do with the ashes. And one simple line in a healthcare directive that said, I want to be buried with my parents in Arizona, would have solved the problem. One silly, simple little line. But it would have been in writing and it would have stopped the problem. So, I mean, these documents are really important, and we get into that kind of detail, or should be getting into that kind of detail. But on healthcare, I think most professionals would agree, unless there's just so much discord in the family that it's necessary, that a family member is often a good choice. Is there anything? Yes, ma'am.
What's the average length of time that a conservatorship takes to resolve? And also, what happens to the finances while you guys are in court? Does it stay status quo, or is there someone that takes over?
Okay, to establish a conservatorship can take a couple of months. And so oftentimes when these cases come in, they are emergency cases. We can get a temporary conservatorship. It usually takes about 10 days to 2 weeks if we're lucky to get one. But it's very, very difficult to get a temporary conservatorship. And while I get frustrated with the judges that they don't make it a little bit easier, I also have seen many seemingly emergency situations resolve themselves in that period of time. So a normal conservatorship, I think you need to plan on 2 to 3 months. If there's any kind of contention or discord in the family, it will take longer. I'm just saying. Yes, ma'am.
I'm just curious, you're representing the family or the people that believe this needs to happen. There's a judge and you say there's a jury. Is there someone appointed to the client themselves representing the client and maybe the client's opinion?
Okay,
or not?
so the question is there somebody representing the proposed conservatee, the person who needs help?
At a neutral party.
Yeah, and so the quick answer is yes. And sometimes I represent proposed conservatees. And a jury is not there every time. It's only if the proposed conservatee objects and says, I want a jury trial. Okay, so normally it's done on a hearing basis, which is just the attorneys, the parties, and the judge, until we have a request for a jury trial.
And then, real quick.
Sure.
And then that person still believes they should not have one, but you get it. How does the family then put all that in place? They just take the checkbooks away and they got somebody fighting, I'm not gonna take a bath, I'm not gonna.
Yes,
I'm not
it's,
gonna eat, I'm not gonna.
you know, it's not smooth sailing. Sometimes there are some rough spots, but the bottom line is if a conservatorship is established, we have now taken away that person's right to the checkbook, the right to write checks, the right to go out and buy a new car when they shouldn't be driving. All those rights are taken away. Okay? Thank you very much. Appreciate it.